So what are you saying? You don't think you're?
I got two, they won't give me my back time when I get to TDC.
Well, let me just tell you.
So
they're
I'll do
not-
4 years,
let me
9.5
just tell
months.
you, they are not in charge of whether you get your back time or not. I'm in charge of that. And what I can tell you is put on your listening ears. Take a deep breath. All right, take another deep breath. This is what I want you to hear. If these cases were pending and you were not on bond for these cases, right? If they're pending and there's a warrant out for you on these cases and you didn't make bond on these cases and you're sitting in custody, you receive credit for that. That's the way credit goes. And legally, that's what you're entitled to. Now, somebody else will calculate your time. I'm not in charge of calculating your time. What ends up happening is I just will tell you, you get credit for any time served that you have been in custody on these cases.
So Judge, I want Dr. Murphy to be able
One
to.
second. Oh, Deputy Mejia.
I'm gonna hold them effective.
All right, thank you. I appreciate it. All right, yes.
Hey.
Hi.
Good morning.
I want Dr. Murphy to be able to visit with him
Okay.
before we discuss the hearings that were set for today. Can you delay this hearing for 2 weeks?
All right.
Yeah, okay.
And a hearing for what?
We're currently on a bond reduction.
Okay.
It was, Judge, I think it was sua sponte file because I did not file any motions for bond reduction. He is remanded without bond on 2 of his cases, 50K on the other. But I really want to get the Dr. Murphy interview done before I address his bond.
All right. So his, let me see.
Oh, and I've also conferred with the state and they're okay with a 2-week reset on that.
So his plea deadline date is actually June 23rd.
Yes, Your Honor.
All right. So how much time are you asking for?
Just 2 weeks to come back on the bond issue.
All
And
right.
hopefully Dr. Murphy will have been there to visit by
I'll
then.
tell you what I'll do. I will, I can set it for June 9th if you want June 9th.
Yeah. Very good.
June 9th, Monday is good, Judge.
All right. Ms. Ferguson on Dixon is coming back for June 9th. Yes. And they want a bond hearing. Yes.
I'll file the appropriate motions to come back.
State on Dixon, they're coming back on June 9th for a bond hearing. He's remanded without bond, defense counsel tells me, on a couple of his cases. All right, thank you.
Okay, thank you, Your Honor.
Just have a seat, sir.
Okay, we hope to ask for Coach James for these days.
Well, Mr. Davis needs to be brought back out here.
Previously, one of back out here.
Yes, I do. All right,
Bring him up.
yes.
Whenever y'all are ready.
Mejia, you bring him out, please? Yes. Judge,
Yes.
and I don't know if I should just make a record of the offer that's being made to him in the ranges of punishment to the defendant outside the presence or if he just found that.
Oh, just give me 1 second. Let me see the file on this case, please.
It ought to be 2 files now.
All right. Mr. Davis.
Yes, Your Honor.
All right. So here's the thing. Whatever agreement you all are able to come up with, that's whatever agreement you all are able to come up with. Now, I understand that sometimes people will look at cases differently. And when they look at them, they think the range of punishment is something else. But then when they discover that there are enhancements involved, then your range of punishment increases. So on each of these cases, they are proceeding on you as a habitual. So normally where your range of punishment may be at a state jail level, it is not when you're being habitualized.
Yes, ma'am.
Now, when it's a habitual in the count, for example, this unauthorized use of a vehicle, normally it's a state jail felony, 180 days, up to 2 years in the state jail facility, and up to a $10,000 fine. That's normally what the range of punishment is. But Texas has enacted through the legislature that if somebody has been to prison before or has previous felony convictions, their range of punishment can be enhanced. What does that mean? That means that even though technically and legally it's a state jail felony, you're not at state jail felony punishment. Do you understand?
I understand it totally, Your Honor.
So here's the thing. The state has made an offer. Do you know what the state's offer is? That's either yes or no.
Yes, ma'am.
All right, state, your offer that you have made to Mr. Davis, is that your final offer?
Yes, Judge.
All right, so just 1 second. State, do you have any plans on changing whatever offer you made to him?
No, Judge.
All right, so they're saying that their offer won't be changed. So whatever offer they made you, that is the offer. Yes.
Okay, I'm just trying to get something straight because last time I got 2 6s concurrent. I signed 2 6s concurrent, but I picked up a case after the first one. I did 6 years, 10.5 months flat.
Mhm.
Right? So they're offering me a 4.
No, I don't want to know what they're offering you.
Well, I got 2 charges. I just got this other charge. I've had the first charge since September, right?
So what are you saying? You
The
don't think
second
you're?
one, I got 2. They won't give me my back time when I get to TDC.
Well, let me just tell you.
So
they're
I'll do
not-
4 years,
Let me
9.5
just tell
months.
you, they are not in charge of whether you get your back time or not. I'm in charge of that. And what I can tell you is put on your listening ears. Take a deep breath. All right, take another deep breath. This is what I want you to hear. If these cases were pending and you were not on bond for these cases, right? If they're pending and there's a warrant out for you on these cases and you didn't make bond on these cases and you're sitting in custody, you receive credit for that. That's the way credit goes. And legally, that's what you're entitled to. Now, somebody else will calculate your time. I'm not in charge of calculating your time. What ends up happening is I just will tell you, you get credit for any time served that you have been in custody on these cases. Then the clerks will calculate that time. If you believe that time is incorrect, there is a legal process where somebody else will look at it to see if it is correct. And if they say it's correct, then it's correct.
I understand everything you're saying here. I mean, it's totally 100% correct. But when I get down there, they're going to start from the most recent one. So that's only 2 months back time. I got 8 months back time, 9 months back time on the other one. I'm not going to see any of that. I'm going to end up doing 4 years.
Well, so this is
4.5 months.
I don't think you're hearing me. So this is what I want you to
They
understand.
can't give me that back time.
I'm not in charge of that. The state is not in charge of giving you your time. They can't say, I'm giving you this time. I legally will pass a sentence on you're getting credit for time that you've been in custody. When you go back to prison, if that's what agreement you worked out with the state, then the prison authorities are going to give you whatever time they deem you're supposed to get. If you don't think it's correct, what you're going to end up doing, an attorney may do it or you may do it, you're going to file a motion saying, I'm not getting appropriate credit. Then what will end up happening, it'll come back to the powers that will be, which will be this court, and I will receive notice from admin saying, we've recalculated the time is correct, or either they're going to say, the time is incorrect and this is how much time you should have. And if they come back to me and say, this is the time that you should have, I will sign it and it will go to the prison authorities and they will give you that time. That's how that works.
I understand that. But I just got indicted yesterday on the most recent charge. I mean, had time to even look at discovery, but I haven't been able to discuss discovery or any case of defense against any of my cases. And this, yesterday was the second time
Well, here's the thing, you're here,
I was ever offered anything the second
Here's the
time,
thing.
Your Honor.
you're here, he's here. Look at the file.
I need, I want to go to trial, but I can't with
Okay.
him. I can't, he will not fight for me. I believe he's not going to fight for me. I need proper counsel, Your Honor. I asked yesterday, we've already, I'm trying to talk without cussing and getting,
No, you can, go ahead.
because like this is my life, right? And if I take it to trial and face him 5 to 99, I know that I've already had affidavits put in, he won't turn it in. Right?
All right, so let me explain to you something about affidavits and the filing of affidavits. If these are affidavits from laypersons, that's not how it works at trial. They have to come in and testify.
Yeah, they're willing to do it.
All right, so then what will end up happening, here's the thing, if you want to go to trial, guess what? In this court, you will get your jury trial. The jury will, if the jury find you not guilty, then they find you not guilty. If they find you guilty, you've already told me you're looking at 5 to 99 years or life in prison.
I'm not, but I don't have adequate counsel to go to trial.
All right, so this is what I want you to do. I want you to sit with your attorney, and I want you all to go over the state's file. And this is what I'm going to tell both parties. Using profanity and anger is a sign of people not being intelligent.
Yes, ma'am.
So everyone should treat everyone with respect. I don't care who you are, what you do for a living. So you both are going to go over there, okay? And then if there's an issue, Mr. Hyde, do you still wish to represent him? That's either yes or no.
Yes.
All right, then have you been going over the documents with him?
I gave him the police report of the latest case yesterday. I was just wanting to check if that was enough issues that he's talking about.
All right, so this is what I want you all to do. Sit over there, talk to each other, and then you can come back and talk to me. And if y'all cannot talk to each other civilly,
Yeah, I have a second to breathe. Kind of got worked up a little bit.
I'm sorry, what?
Can I have a second to breathe? I kind of
Sure.
worked up a little bit. Just pertaining the case, and I know when you went over, you seen that the protective order was violated multiple times. It's not. I know it. If you read police reports or a person's victim's testimony of what happened, sometimes it could, it's up to the court, your discretion to see if, try to make sense of it, I guess. But when it comes to probably a protective order, we have children together, and to be honest, like I never been in any trouble before in my life pertaining like legal system and having to no contact, like the contact order with my children. And I was a sole provider for my children. Like she was a stay-at-home mother, and when I went back home, like the no contact order, I went back home, but I was the only person on lease, and I didn't have anywhere else to go. And honestly, from what we talked about pertaining me and her, we were fine on good terms, etc. So to be honest, I didn't think it was gonna be any more.
But see, here's the thing about it is that there's an offense against you for choking, right? And when you think about it, choking a person, that means you're face to face with them. They can't breathe, and you're still choking them. Now, you have that, so you have to know that there's a no contact order in place. And when you're saying, oh, well, I leased the apartment or the house or whatever, that's why I was going back there. Okay, I understand that. But when you were placed in custody at the jail, both parties agreed, your attorney agreed and the state agreed that you were actually contacting her from the jail. And so the thing about it is you already have this violent offense for choking someone. And then on top of that, you are continuing to contact them from the jail. You had to know you couldn't contact people from the jail. And that just shows the court that you can't follow rules. And she has, according to the testimony that is taken, she left town and is no longer in Texas or wherever she may be. Then, it is what it is. She left town. Maybe she left because maybe she's thinking, I leave town, he doesn't know where I am, then he can stop contacting me. But that's where we are.
Yes.
Sure.
Okay.
To be, I don't know how much I say before.
Well, you're not under oath.
Oh, okay. Well, I could speak freely. Yes. Your Honor, he came back and forth to see me unannounced. Came to the house unannounced. When she was in a woman's home in Fredericksburg, she was they kicked her out of the woman's home, and the police had to come or whatever to escort her away. She came to the house on February 4th or 5th, unannounced, midnight, because I wasn't speaking to her because we were talking during the protective order. We have children. I was sending money for my children, or she would bring the children so we could see them. We would eat together.
Right, so here's my question. Were you sending money to the children from the jail? That's a no.
No,
But you were still calling her from the jail, and that had nothing to do with anything. So here's the thing. I wanted to hear you out because I know I didn't get a chance to fully explain to you why I didn't grant you probation. But the reason why I didn't grant you probation is because you have a crime where you choke her. And then after you choke her, you continue to contact her. What I'm letting you know is I understand, okay, you're on the lease, you go to the apartment or to the home because you're on the lease and you're trying to make sure that the children have food or have money. That's fine. But then you proceed to call her on numerous times from the Bexar County Jail. That's a no. And for the court, part of the reason why I didn't grant you probation is because based upon your actions, you're telling me you can't follow conditions of probation. So that is why.
I actually, Your Honor, if possible, because before this happened, I was enlisted actively in the military. I was enrolled into medical school for LMRT classes to become a radiologist. And my classes started in March 2025. I've been in and out of grew up in the jail, etc., house arrest, etc. since then. I understand exactly where you coming from and have a concern to the court or, even like the charge, or etc. I've been sitting in jail and dealing with different health reasons, low potassium and low liver enzymes since the date of my arrest, December 5th to March 18th. I was admitted to the hospital. I had lost 110 pounds because I wouldn't eat because I had psoriasis, which is like my skin breaks out from certain foods, meat, dairy, etc., sugars, heavy. I grew up in a family with my immediate household was my father, my brother, and myself. Out of us three, both of them are felons, and neither one of them graduated high school. I'm the only one who graduated high school. I'm the only one who wasn't a felon. So applying for the probation and adjudication was trying to save me from becoming a felon. I took pride in not having any criminal history. If you could so grant me, I don't have obviously lawyer here, but I was thinking,
You can always come back with your attorney. I tell you what, I'll have you come back with your attorney. If you want to come back with an attorney, you can.
no, I'm just speaking to you. I mean, it's up to you. I mean, I just don't want to be a strain on my family, and being that I know that I would abide to any probation adjudication, especially the first. I can try to save my record and save me to be able to go on and have a career in any field or even enlist in the Army still. I would say if you could maybe think or ponder on doubling the sentence to 8 years probation deferred and double the fines. And if you could possibly consider a no harmful contact, because Carissa has my children and Carissa has my children, she has my car, she has a bunch of my possessions. No, from our family, both of our families know each other. I knew Carissa since I was 14 years old. Both of our families know each other. Carissa doesn't, she's left her family.
Let me just tell you this. What I would suggest to you is speak to your attorney.
Mhm.
The reason why I had you brought back is because I felt that there is something you wanted to say. And I know I didn't get a chance to explain to you why I made the ruling I made.
Mhm.
And I will tell you, we're always taught as judges never to explain our rulings, just make the ruling and move on. But I don't like to do that because I don't want people to think that I haven't heard their story or I'm not paying attention to them or that I'm not looking at them as individuals. So I noticed as you were being taken away, you were raising your hand. And that made me realize that I really didn't get a chance to explain to you why I ruled the way I ruled. Now, if you're asking or wanting me to perhaps do some type of different sentence, and for me to consider that, then your attorney will need to file a specific motion for that. The coordinator will let your attorney know, and we'll go from there. Okay?
May I say something?
Sure.
From I was told yesterday that my lawyer or attorney made motions for reconsideration and a bunch of other motions.
I haven't received those.
That's what I was told from my family when I called them. Before I went up here, this is all off the record.
Yeah, we're off the record. The court reporter is not taking anything down.
I didn't understand what I signed with the silent.
All right, so here's the thing. You need to talk to your attorney about that. So everything else that you're about to say now, you need to talk to your attorney. Your attorney can file whatever motion she chooses to file, okay?
No, I was getting to what
No, you're getting to places that you should not get to.
I was up there, but I'm saying that before we came up here, I was told several times that I could be able to.
No. Here's the thing. You are now trying to, attempting to wade into legal matters. And I think you should have your attorney here to discuss that. All right? So, Ms. Ferguson,
Yes,
has a motion been filed by his attorney?
I need to double check that. Judge, do you have these case number, Judge?
No.
They're right.
Okay. All right. And if they have filed, if she has filed something, we'll put it on a docket for it to be heard, and Ms. Ferguson will set it. So just have a seat, and Ms. Ferguson, if she finds something, we'll set it. All right? Okay. So when are we available to hear whatever motion she has filed?
I can do it the first week of June. I need to contact Anita to make sure she's available.
All right. So as soon as your attorney is available before 30 days, we'll hear her. Okay? And if you have some type of food intolerance, you need to let the jail know. If you let the jail know, they will prepare you a specific meal.
I literally, this is all in the notes. This is all the thing I told, when I had Zoom port for the protective order hearing, I would go to Zoom port in jail, and I told,
Deputy Mejia,
Yes,
will you please let the jail know that he has food intolerance to dairy?
Yes, sir. No, it's not just dairy, it's meats, processed foods.
All right, he can't eat any processed food. Will you let them know that he needs to eat green? Yes.
Your Honor, he needs to submit a sick call so they can verify he does eat, that he's allergic and can't tolerate that.
Yeah, I can tell you exactly what happened. I was in jail for 34 days.
So here's the thing. The only question that I need to know is, did you submit what form he did?
It's a lot of medical blood work. I took
Did
a lot
you
of,
submit it?
I've been in and out of, yes, I went to
No,
the
my
hospital.
question is, did you submit the form to the
Yes.
proper people?
Yes, several times.
All right, so Deputy Laura, if you can make sure that the jail has the information on him, and I will send an email.
And I didn't eat until I went to the hospital after 30.
I will send them an email about your intolerance. Is there anything else?
That's it.
All right, so I'm going to send an email right now about your food intolerance. So what specifically can you not eat?
I was wanting to just get some type of fruit, and they didn't give me any fruit. They said because it's hooch and all this.
Okay,
other
this is
stuff.
what I want I want you to listen to me and internalize what I'm saying. As my grandmother would always say, it's not about who shot John right now. So somebody did something or they didn't do something. I'm not at that point right now. Where I am is you're telling me you have a problem. I'm trying to solve it. So I don't need to know the backstory. I'm just trying to figure out, what are you not allowed to eat? What can you eat? And I will send an email to the sheriff letting him know that you are not allowed to eat dairy. So other than dairy, what else can you not eat?
Meats, processed food. I just really fruits and vegetables.
All right. So you're not allowed to eat meats or processed food. And what are the results if you eat meats or processed food?
I have skin breakouts in my face and hair area, etc. And it gets like red irritants with psoriasis.
All right.
I didn't mean to agitate.
No, I mean, I just want you to tell me, what can you not eat? The fact is calling 2025 CR 002426 State versus Axel Ramirez. Can I have parties announced?
Megan Galloway for the state.
Trey Maurer standing in for Robert Maurer for Mr. Ramirez.
All right. And are you Mr. Ramirez?
Yes, ma'am.
Do you have any objection to this attorney standing in for Robert Maurer?
No, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
We have, Judge.
Court will find that the state is in compliance with discovery. Mr. Ramirez, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with intoxication, assault with a vehicle, serious bodily injury as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this cause?
Yes, ma'am.
And counsel, it's the court's understanding that he's only applying for community supervision. Is that correct?
That's correct, Judge.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Ramirez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 6 years in the prison. There's a $2,000 fine. There's no application for deferred adjudication. The state opposes your application for community supervision. They will take in consideration 2025 CR 002422, and there's to be restitution of $100 to the complainant. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
They're not, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
State offer states one in attachments.
No objections.
I state you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call them the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. If you would like, I can set this for a PSI. It's going to be probably 8 weeks because that's the time frame. Or if you all would like, I can set it sooner and you can have whatever witnesses you would like to bring in to testify.
Your Honor, can we take a step back and confirm real quick,
Sure.
if I figure out what lead counsel wants to do on that?
Sure.
You said either 8 weeks or
Or we can come back sooner, but that would mean you would be waiving your PSI and I would make a decision based upon whatever evidence is presented to me.
okay, let me take a step back and confirm real quick. Thank you,
All right,
Judge.
thank you. All right, are you all ready on Tovar? All right, so you filed a motion for a bond. The reason why he doesn't have a bond is because he failed to appear
Yes, sir.
February 18th.
Yes, Your Honor, and
All right, we'll go on the record. Court is calling 2024 CR 012895, State versus Mario Alberto Tovar. Can I have parties announced?
Megan Galloway for the state.
Christopher Simpkins for the defense.
And are you Mr. Tovar?
Yes, ma'am.
All right, defense has filed a motion requesting a bond. State, have you had a chance to review that?
Yes, Judge.
All right, counsel, in your motion, you say he is entitled to a bond, and actually he is not if he has previously failed to appear. But
Yes.
what I'll let you know, I'm keeping an open mind.
Yes, Judge, and I believe the reason that he failed to appear is because he was in an inpatient facility, which I did not get the case till January of this year, and I believe he went into the inpatient facility in December.
December 12th.
All right, do you have documentation of that?
He was benched back to Bear County. I'm working on getting the documentation, but he was benched back to Bear County, which the system should reflect that.
Okay, let me see what the system reflects. All right, so we're off the record. So what I see in the system, there's an affidavit of surety file, affidavit to surrender surety, August 2024. Then we had an affidavit to reinstate bond on September.
And he was.
Then there was a warrant return. I don't have that
He was booked in on May 6th, I believe, and he was transferred from which class?
Gloucester.
let me see. Let me go to the next screen.
On September, I was, I paid the bond and they.
No, talking about when you were brought back, or when you were brought to Bear County, which county were you brought here?
From San Diego, Texas. Gloucester.
I don't have that listed on here. To the clerks, can you all see if he was brought back from an inpatient facility or something? Because I don't see
He was
that.
discharged from the inpatient facility once the warrant, so that they could bench him back.
Checking.
Okay.
Yes.
But Deputy Lord, thank you for giving me that information from the jail.
You're welcome.
What are we looking at?
Defense counsel said that he was in an inpatient facility and was bench warranted from the inpatient facility.
San Diego, Texas, I believe. He doesn't. There's how many sense.
I was in Eagle Pass. They sent me from Eagle Pass to the Gloucester unit, and then from the Gloucester unit, they sent me in.
But you're saying that you were in an inpatient facility?
Yeah. It was a safety.
Oh, okay. So he's saying he was sent to safety,
That's for, he has a
and then that from safety, he was brought
yeah,
here.
and he was discharged from safety because of the warrant out of. Bear County.
Okay. Well, that should be easy to find out.
I'm just trying to. A lot of the counties and down there, they don't have very good.
And so what were you on probation for in the other county that you were sent to safety?
It was a drug charge.
Okay. All right, so they don't have anything. That he was bench warranted back from safety. I didn't have anything in my system either. But here's the thing, I may not have anything in my system, but it will be easy to get that information at a later date. So we're back on the record. What are you requesting?
I would just ask that the bond be reinstated in the original amount. I know that the bond itself cannot be reinstated, just the original amount. And I will see if the bond company is amenable to reinstating their bond in it, just so he has the option to make one.
And state, what are you requesting for bond?
Judge, the original bond was $10,000, so we're requesting a bond to come out $10,000. This conditions.
All right. So this is what the court is going to do. Based upon your telling me that you're in safety, if your client can bring back proof to the court that you are actually in safety, then I will reinstate the bond amount to the $10,000. But for now, your bond is going to be set at $20,000 because the only thing that I have is that you didn't show up for court. And bond is supposed to be high enough to make certain that a person will appear, and you didn't appear when your bond was at 10,000. But if it turns out he was in safety, your attorney can come back and I'll set the bond at $10,000. But for now, your bond will be $20,000. There's to be regular UAs and outpatient treatment. All right, is there anything else?
Nothing further, Your Honor. Thank you.
All right, so Ms. Ferguson, can you make sure that he has his reset form?
Yes, ma'am.
And I believe he's set
July.
July 8th. Yes.
Sure.
I'm ready to proceed on that, actually, whenever you.
All right, just give me one moment. Let me put this in the system.
Like, send them through one.
All right, yes, Mr. Maurer.
You're gonna request a PSI, Your Honor.
All right, I need a PSI date on Ramirez.
July 14th. Judge.
All right, it will be July 14th. July 14th, yes, you'll sign the reset form. So that's going to be a PSI and a TAP evaluation. And before you leave, speak with probation and they'll let you know what you need to do.
Okay, ma'am. Thank you.
Okay, you're welcome.
PSI on that?
Yes. All right, who's here on Alan Mineros Pettis? Is this on the docket today?
No, Judge.
Oh, no, Judge, that was just printed out.
Okay.
Was
this person sentenced?
Yes, ma'am.
Okay.
And he's probably knows.
All right, thank you. All right, who's here on Anthony Rosales?
I am, Your Honor.
Court is calling 2024 CR 2791A State versus Ethan Anthony Rosales. Can I have parties announced?
Brandon Galloway from the state.
Trey Maurer, standing in for Robert Maurer for Mr. Rosales.
And are you Mr. Rosales?
ma'am.
Do you have any objection to this attorney standing in for Robert Maurer?
No, ma'am.
Counsel, you received all discovery. Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Rosales, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
And counsel, are you all applying for deferred?
We are, Your Honor.
Mr. Rosales, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Rosales, did you review the court admonishments and waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with deadly conduct, discharging a firearm at individuals as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Just one moment. All right, we're back on the record. Did you understand that if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you enter a plea will not be used against you and you will be allowed to withdraw your plea.
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe so, Your Honor.
Mr. Rosales, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 7 years in the prison. There's a $1,500 fine, and the state is silent on your application. Did you understand that to be the plea?
Yes, ma'am.
Defense?
It is, Your Honor.
State?
It is.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There were not, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty, ma'am.
State any evidence.
State offers states one in attachments.
No objections.
All right, state you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. and 02586 State versus Charles Lewis Mullinax. Could I have parties announced?
Jason Garahan for the state, Your Honor.
Victoria Cruz on behalf of Raymond Martinez for the defense.
And are you Mr. Mullinax?
Yes, ma'am.
Do you have any objection to this attorney standing in for Mr. Martinez?
No, ma'am.
All right. State, have you reviewed the motions?
I've reviewed one motion for one case, Your Honor. That's on the 524.
Your Honor, I believed only the 524 was remanded. I thought the others had a bond amount.
Oh, okay. So we're only going on the
524, I believe.
524?
I think so, yes.
Okay.
I'll check with that.
So do you all have an agreement to a bond amount?
State recommends 4,000, which is double. That's fine with us. The original was 2,000.
All right. So why doesn't he have a bond in this case?
He FTA'd, Your Honor. He did explain to me that the reason he FTA'd was because he was injured. He had some broken ribs and he believed that he would be taken into custody. So that's why I do believe that the period of absconding was only a couple of weeks. And he has been in custody since March 18th.
Let me pull up his case on Odyssey.
Only this one has a warrant. That is remanded, right? I think all the other ones have. No. I asked my staff.
All right. So in this case, there was an affidavit to surrender surety on February 11th. And then he didn't appear on February 24th. And then you're set for jury trial on July 22nd. All right. You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth? So help you God?
Yes, ma'am.
All right. You can lower your hand, state your name for the record.
Charles Lewis Mullinax.
All right. Do you have any prior drug use in your past?
Yes, ma'am.
And what would that be?
Heroin.
All right. And have you ever been diagnosed with any type of mental health issues?
Yes, ma'am.
And have you received medication for that?
I did for a little bit until I got taken off of, like, my insurance got dropped, and then I couldn't afford the medication. I was on it for like a good year though, and I was doing good when I was on my medication.
All right. So I'm going to set your bond at the $4,000. There's going to be regular UAs, a referral to Center for Healthcare Services, and outpatient treatment for substance abuse. Is there anything else?
Your Honor, I was mistaken. There are two other cases are remanded without bond.
Okay.
000.
All right, state. Look at those.
Sorry. This is my fault. So 586 is at was that 5,000? So you want double, which is fine. And then we did, trying to redo right now, 54. 525 is also remanded. Last amount was 2,000 on that one.
We got
Is that it?
So, yeah. So,
It's a 52.
I'll say time.
Yes, that's fine. And that should be it.
Judge, we drew on this though, so.
Okay. All right. So then, and the cause number ending in 25, do you all have an agreement?
We do, York.
And what would be the agreement in that cause number?
I believe that's $5,000 agreement, yeah.
Okay. So in that bond, I will do the $5,000. And Mr. Mullinax,
Yes, ma'am.
I'm going to give you the same condition as I did in the previous bond. Don't worry, you don't have to do it twice. It's just so that they can
Yes, ma'am.
mirror each other, all right?
Yes, ma'am. Yes, ma'am.
All right, and then in cause number ending in 86.
Yes, Your Honor, that's 4,000.
All right, Ms. Ferguson, if you'll make sure that he has a reset form for his July 22nd trial date.
Yes, sir.
All right, is there anything else from either side?
No, Your Honor.
Then in that last cause number, Cindy, it's going to be a bond of $4,000 in 2025 CR 002586, a bond of $5,000 in 2025 CR 000525, and a bond of $4,000 in 2025 CR 000524.
Sorry. The 2586 is the one that had $5,000 bond originally,
All right.
and the other two were at 2,000.
All right, well, this is what they've agreed to, so I'll go with what they've agreed to. But thank you. And in each cause number, it's going to be regular UAs, a referral to Center for Healthcare Services, and outpatient treatment for substance abuse.
Yes, ma'am.
Is there anything else, sir, that you need to be successful on bond?
Not that I could think of, Miss.
All right, if for some reason the referral for the Center for Healthcare Services is not done,
Yes, ma'am.
just contact your attorney and they can contact me and I'll make sure that we figure out what's happening.
Yes, ma'am.
All right,
They waive it. Secondarily, they have run the TCIC and CIC for these individuals, which is the triggering event. The database is curated not by this office. It's curated by the Texas Department of Public Safety and the FBI. They query that database. They are only allowed to query that database if they have a good faith reason to do so in the execution of their duties and responsibilities as members of the district attorney's office. They can't just go pull NCIC, TCIC on you or me because they're upset with us or they for a petty
you're
difference.
saying that they were upset with somebody, that's why they.
No, I'm giving this as an example. I have had cases in the past where I have defended policemen who were accused of improperly querying the TCIC, NCIC database for petty reasons.
So we're not saying that any NCIC, TCIC was queried without a good faith basis.
No. In fact, quite the opposite. We know that there was a good faith basis because this is the TCIC, NCIC for their witnesses. And Brady versus Maryland and every case that has come since it says that they have to give me that information. That
Okay,
is a
so
requirement.
then
So-
the main argument, and so let's stick with what the argument is. And if I'm wrong in interpreting what's being said by both parties, the argument is not that you received the information. Your sole basis is that you should have been allowed to photograph or reproduce or take the item, the NCIC, TCIC with you.
We
Is
want,
that your?
we wanted to be able to use it in every single way that you can use.
No.
the
My
paper.
question, I'm trying to get to specifics. The specific is,
The
well,
specific,
let me start with this. Number one, was the NCIC, TCIC provided to you? Yes or no?
it was handed to me and I had about 10 minutes with it before we had to turn it back over.
Okay, so now with regards to it being handed to you, then it was handed to you. The next question is your sole objection or request for a motion for new trial with regards to point one is that you were not allowed to photograph it or take it with you. Am I correct in that?
The contention is twofold. The first problem is that we were not allowed to photograph it, take it with us, duplicate it in any way. We had to turn it back over. And as we explain in our second argument, that became an acutely problematic issue because we were unable to make use of that information to respond to the state's argument that for authenticity reasons, we were not entitled to offer Joanna Reyes's prior judgment of conviction at sentencing.
All right, so let's start with this point. First point, state, when was the NCIC, TCIC given to defense?
Prior to jury selection, Your Honor.
And the prior to jury selection, was this the NCIC, TCIC that was given to the defense prior to the jury selection? Do you remember which witnesses those would have been?
It was for all witnesses listed in the discovery.
So would that all also have included Joanna Reyes?
That's correct, Your Honor.
So you're saying that was given prior to jury selection?
It was, Your Honor.
All right. So it's the court's understanding that for purposes of cross-examination, NCIC, TCIC are considered timely if they're given before cross-examination. But my understanding is that the state gave it to you prior to jury selection. So the first question is, were the NCICs, TCIC given to the defense prior to jury selection?
A stack of paper was handed to me.
No, my question is,
I want to make sure the record is clear.
I want
because
the record
first
to be
question
clear,
is
too.
not accurate. I mean,
I want to know, they're saying that they gave the NCIC, TCIC of all witnesses to you before jury selection. And it seems your main complaint in here is regarding Joanna Reyes. So my question for the defense is whether or not the NCIC, TCIC, for all the state's witnesses, were they given to you prior to jury selection? Then we can handle your other point.
the word given is not a word that I can address in that.
Were they handed to you?
I held them in my hand for a few minutes. I didn't have an opportunity to digest their contents fully. I wasn't allowed to copy them. Almost immediately afterwards, I was told that their position was going to be that I wasn't going to be allowed to copy them. I had to instruct my
Okay, so
staff.
here's the thing.
Let me just finish real
No,
quick.
no, 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 no.
You know what?
No,
I need to-
because-
I
no,
need to
stop. We're taking it one point at a time. My first question is, were they given to you prior to jury selection? It seems that your answer to that is yes. Then we'll get into what you were not able to do with them. So the record is clear. My understanding from you is that witnesses who are going to testify in the state's case in chief, their NCIC, TCIC was given to you prior to jury selection. Now that that's been established, then the next question becomes, what were you able to do with the NCIC, TCIC that was given to you?
Nothing.
All right. So you said, were you allowed to elect, because in your motion, you say you were not allowed to electronically duplicate. Were you allowed to electronically duplicate them?
No.
Were you allowed to copy them?
No.
Were you allowed to photograph them?
No.
And I'm taking that straight from your motion. So state, with regards to the NCIC, TCIC that was handed over to the defense, you're saying it was all of your witnesses in the case in chief.
Yes, Your Honor.
The defense is saying they were not allowed to electronically duplicate, copy, or photograph any of the NCICs, TCICs. Now, why were you not allowing the defense to either electronically duplicate, copy, or photograph the NCIC, TCIC?
Because I didn't want to be charged with a misdemeanor offense.
All right. And where are you obtaining that from, the fact that you would be charged?
Your Honor, I previously stated there are two subsections of law that govern the dissemination of criminal histories. The first being Title 28, Part 20 of the Code of the Federal Regulations, and then the second being 411.083 of the Texas Government Code.
All right. So the state is saying that they could not allow you to electronically duplicate, copy, or photograph based upon Title 28 of the Federal Code and also Chapter 4 of the Government Code. What is your response?
Several things. First, we do not believe that those provisions prohibit a defense lawyer from taking possession of the criminal histories for the purposes of defending a man at trial. That is not the purpose of those laws. That is our position. Secondly.
All right, let me just stop you for a moment. When you say taking possession of it, what do you mean by it doesn't prohibit you from taking possession? What is your definition of taking possession of the NCIC, TCIC, as you see it?
A lawyer should be able to keep the paper with him for the course of the trial so that it can be read, it can be understood, and it can be researched further.
All
And
right.
none of those things were able to be accomplished. I was unable to finish reading the histories. I was unable to digest their contents or understand them or make any meaningful use of them. I was unable to copy them so that I could do that when we weren't in court at recess at any point.
All right, so when you say taking possession, you mean keeping the paper. And when you say keeping the paper, for the record, we're talking about the NCIC, TCIC. When you say keeping the paper, do you mean leaving the courtroom with the paper?
I mean, right, I could not leave the courtroom with the paper. I could not photocopy the paper. I could not make use of the paper. And we had to give it back at the end of the day or at some point during the process. I wasn't able to read or digest the information while I was participating in my other roles as being Mr. McIntyre's lawyer. Counsel said it was handed prior to jury selection. That sounds right. I don't have independent recollection of the day, but we were involved in jury selection for all day and into the evening. It was a lengthy process, and so there was not an opportunity to make any use of it. Also, I can just say, Your Honor, in both federal and state trials that I have participated in, I have never had this issue come up before. I have had prosecutors with the Department of Justice hand me the Jenks material, which would include the criminal history material, prior to the commencement of trial. I understand that the Jenks Act similarly narrows that compulsory moment of disclosure to when the witness is passed for cross-examination, but almost every judge in the United States has recognized that while that law may be that that's when it must be produced, that isn't a fair system. It doesn't provide for meaningful cross-examination.
Okay, then somebody needs to change the law. And counsel, I'm sure as you're aware, sometimes people do things that are inappropriate legally, but they do them and nobody ends up saying anything. Nobody ends up charging anybody within anything. But in this court, I'm just here, Mr. McIntyre, to listen to arguments and follow the law. That's my role here as far as this case is concerned, because the jury trial is the parties that made the decision.
But Your Honor, what I'm saying is I don't think that the law has to be changed because I don't think that the law comes to this conclusion. I think that the conclusion the state's asking you to draw from it is not what the law means in its full synthesis, and that the court's responsibility is to allow the lawyers to be able to provide a meaningful defense to the defendant, which includes having access to the impeachment material that is involved in the case. And in particular, Your Honor, what I think we also need to draw clearly is that this isn't just about the general frustration, although there is that general frustration of not having the ability to use that information and have it on counsel table's desk at the exact time that we are in cross-examination or preparing the evening before with that information. Those things all occurred. And so there is a global harm there. But the specific and acute harm, and the reason why a new trial should be granted in this case, is because, as ground two establishes, we have a situation here where the prosecution has misrepresented the criminal history of its most important witness and did nothing to correct that record, even though the very documents we are talking about here, the TCIC, NCIC records, are the proof that it was a misrepresentation. And so that's what really ties this thing together, is that the TCIC, NCIC is being used as both a shield and a sword against the defense. And that's not its purpose. That's the bigger overarching issue here. And certainly with respect to both constitutional law, as it pertains to what due process of law for a criminal defendant means, and in terms of the full synthesis of why these laws exist and what their purpose is and how those things are supposed to operate, it simply is not the case that the court could not authorize the defense to have access to that information during the proceedings. And we were amenable then, we told the court we were amenable then, that we would have taken it under protective order. But that option was not explored.
All right, so with regards to the defense request for a motion for new trial under point 1, that will be denied. Point 2, misstatements of the prosecution in closing argument. What misstatements?
The the state in closing argument told the jury that Joanna Reyes should be credited with belief because she had abided by the conditions of her bail on her tampering case, on her capital murder case, and had not done anything illegal, had not broken the law. and we quote the arguments verbatim in the motion. We approached and explained that's just simply not true. Joanna Reyes, after she was charged in Mr. McIntyre's case, and after she entered her plea of guilty to tampering with evidence, and after her sentencing was held in abeyance and postponed pending the outcome of Mr. McIntyre's trial, she went out and obtained criminal conviction for the felony offense of credit card and debit card abuse. She was also arrested and charged with unlawful carry of a weapon. That case was dismissed because she pled to a different offense. We've included all of those records that we've obtained from the Harris County clerk as exhibits in the motion for new trial, which we'd ask that the court receive. We also made a bill of exception at the trial of the judgment of conviction for credit card and debit card abuse at the sentencing phase of the trial, which we'd ask the court to take under consideration as well. There's just no question that the state told the jury something that isn't true. Now, listen, I think Jason Garahan is a very reputable, honest, and hardworking prosecutor, and I have immense respect for him. I don't know why they said this, but it's just not true. It's objectively false.
All right, response.
Well, Your Honor, with respect to the statement, I trust that their motion states what I said during argument, which is closing argument during the guilt innocence. And what it may be, slip of the tongue, or the fact that I misstated that Joanna Reyes had I don't know exactly what was said, but alluded to the fact that she didn't break her bond is something that can be argued that was done by mistake on my part. That may be, but the fact remains is that defense counsel knew about this and did not bring this up during her cross-examination. And the fact is that the jury is well aware of her credibility or credibility issues, if you may, of her being a co-defendant to a capital murder and of her testimony that she gave during the portion of guilt innocence. And touching on the subject of the prior judgment, defense had every opportunity to recall Joanna Reyes onto the stand during punishments, which they chose not to do. And, if they consider our duty or their duty, the fact is that their client was the one that was facing 5 to 99 years of life. And they could have called back Joanna Reyes and questioned her on the subject, and they chose not to. That fact does remain there, Judge. So that's the state's position on it.
Judge Am, just one more thing. Closing arguments are just that, arguments. They're not evidence. And the jury was instructed about that multiple times. And so that would just be another argument regarding that.
All right. With regards to point 2, the motion for new trial will be denied with regards to point 2. All right. Thank you.
May I be excused, Your Honor?
Yes.
I guess, well, we don't need the other. I'll be filing an amended notice of appeal to include the denial of the motion for retrial.
Sure. All right. Is there anyone else who's ready?
But he's got,
Is that your turn?
yes.
Just to let you know about that, I talked to Adam. And, I sent an email off to our investigator to check into another SCPD case number that's possibly associated with this, his client's case. And I know that he probably won't mind me telling you that he doesn't want to go forward until possibly there's an answer on that.
All right, Norma, on Mr. Alamon then? Let me go into the calendar. Mr. Alamon? I know I'm mispronouncing your name. I am so sorry. You can come down, please.
If you want to put my head out there and see if it's there.
Sure. I'm going to give you a new court date. Your attorney believes that there may be another case that's pending, and he'll need discovery on that.
Yes, ma'am.
So what I'll do is I'll bring you back on June 26th. And if your attorney wants you brought back sooner, he'll let us know. If there are any other motions to be filed, he'll let us know, okay? All right, thank
In this courtroom session, everything starts off routine, but quickly turns serious as the judge lays down strict control over the room. One by one, names are called, and the warning is clear. If you're not present, a warrant could be issued immediately. As the cases move forward, the judge deals with the defendant facing enhanced charges as a repeat offender. The stakes are high, and the judge explains in detail that prior convictions can drastically increase punishment, turning what might have been a lighter sentence into years behind bars. The defendant tries to argue about time credit and fairness, clearly frustrated, but the judge shuts it down and brings focus back to reality, explaining that sentencing, time calculation, and prison credit all follow strict legal processes, not personal opinion. Tension rises when the defendant claims his lawyer isn't fighting for him, but the judge immediately steps in, reminding everyone that anger and disrespect won't help. Only clear communication and proper legal steps will. And in one of the most real moments, the judge says it straight. If you want a trial, you'll get one, but if you lose, you're looking at serious time. This courtroom proves one thing: the system will hear you, but it won't bend for you. Like and subscribe for more real courtroom moments.